Morning, everyone. Welcome to today's webinar on the Data Use and Access Act, which is the biggest reform of UK data protection laws since UK GDPR, has quite a lot of impact for schools. I'm Joanne, and I'm a partner in the commercial team here, and I lead our data protection practice. I'm presenting today with Hannah, who's also an associate who's also in the team and specialises in data protection. We're also members of the education sector group. So we do see a lot of data protection issues relating to education. We're seeing a lot of DSARs at the moment. We see people wanting to implement new technology in the education sector and what the issues are with that. So we do see, as I say, a lot of diverse data protection issues relating to the education sector. We're going to go through the key changes today, and we're going to start by having a look at the sort of background to the Act and the purpose of the Act. Before I forget, I will remind you that there is a feedback form. There's a QR code for feedback. It'd be great if you could feedback and fill in the form. It will appear later as well towards the end of the presentation. So moving on to the next slide. Data protection reform has been on the cards for a while. It was thought that sort of European GDPR was quite detailed, made it quite difficult for smaller organisations to comply with it, quite a lot of red tape. So the UK government, various governments, had been considering data protection reform for a while, started with Liz Truss's government, and it's ended up after various bills with the Data Use and Access Act. It was passed in June this year, but I think it's worth bearing in mind that it's not all come into force in June. It's happening piecemeal, and I'm going to have a look at the timetable for what's happening when in a mo. As I said, the point behind it is partly to reduce red tape, to make it easier for people to be compliant with data protection laws. I think a lot of people are keen to be compliant, but find it very difficult in terms of all the hoops to jump through. And there's also a strong focus on innovation, certainly in the more commercial sector, in terms of helping with innovation and pushing that forward. So moving on to the next slide, we've got the timetable, and you'll see on the timetable, as I say, it came in June. In autumn 2025, there have been some draft codes of conduct that have been issued by the ICO. There is one in relation to data protection complaints, and also one in relation to something relating to recognised legitimate interest, which Hannah's going to talk about later. Further guidance is expected in the winter, and I think with the change in the weather, we're certainly in winter now, so we're expecting that pretty soon, and you'll see on the slide what we're expecting then. 19th of December marks the 6-month mark. We have been told that most of the provisions not in force relating to data protection will be enforced then, but there is a delay in relation to something relating to what's called a charitable soft opt-in, which I will talk about later, and that's coming in January 2026. I've put a deadline on there relating to EU and UK adequacy. One of the things that's important about this legislation is making sure that we don't lose EU-UK adequacy, because at the moment data can flow backwards and forwards from the UK to the EU and vice versa. That's important. You might not sort of have links with schools in the EU, but it's important from a supplier point of view in terms of suppliers these days obviously are more diverse in terms of where they're located, and so the free flow of personal data is important. Full implementation is the 19th of June next year, but I think a lot of the data protection stuff should be in by then. So moving on to the next slide, we're going to now look at key proposed changes. It's a bit of a whistle-stop tour because there is a lot to cover, but obviously if you have any questions, please do reach out. So I'm going to pass to Hannah now, and Hannah's going to pick up at the next slide, looking at children's personal data.
Thanks, Joanne. So children's personal data, it's always been something considered that it needs special protection and handling. And this is because children are unlikely to be able to understand the risks, the consequences and the safeguards involved in data processing and their rights in relation to it. So this in turn makes them more vulnerable to misuse of their data and exploitation. So the GDPR Act reinforces that children's personal data should have a higher level of protection, particularly where children are likely to access information society services. So these services are things like social media, streaming services, and apps. So this means when it comes to EdTech, it's important to understand how the educational platforms and apps that you might use within school and college are put together and how they work. And it's something that you should consider when you're doing your due diligence on your EdTech providers. I'll now pass back to Joanne, who's going to have a look at AI and what GDPR means for that.
Thanks, Hannah. Obviously, AI is a big topic, and one of the main concerns around AI is its use of personal data. I think before we look at that in detail, it's probably worth just setting the scene a little bit. We don't currently have an AI Act. The EU does, but we don't. The government currently takes a sector-based approach, so it expects regulators like the ICO to regulate the use of AI. But we have been told that there will be an AI bill in the spring of 2026. So it'll be interesting to see what that covers. At the moment, I think it's probably worth having a look at what the DFE say in relation to the use of AI and also what the ICO is saying. So I think one thing that's worth bearing in mind is the DFE are very clear about its preferred type of AI that schools should be using. There are two types of AI, one of which is ring-fenced and the other one is an open system. An open system where you put things into, say, a large language model and you put information into the AI, it goes into the whole knowledge of the AI and it's used for training the AI generally. Obviously, there are issues if you're putting any sort of student or pupil personal data into that in terms of putting it out there. Ring-fenced AI systems mean that the personal data or indeed the other information that you put into the AI stays within the organization. It doesn't go out into the general model. It doesn't go out for general training of the AI model. So as you can appreciate, the DFE is very keen that schools check any AI in terms of, you know, if it's a large language model that they're using, but also if AI is built into any of the tech that's being bought. And I think that's one thing that is worth bearing in mind, and we have seen this, is that schools and sometimes will buy in technology, and we've seen AI being built into things, even things such as HR systems. So I think it's important to understand where AI is, what AI you've got within the school, because it might be included in products that you weren't really aware of. The other thing that the DFE is keen on is clarity and transparency, and that's also something that's a watchword from the ICO. By transparency, that essentially means the use of privacy notices and being very clear in a privacy notice about what AI tools are being used, what personal data is going into them, how they can be used in terms of, for example, are you using it in the classroom? Are you using it you know, for lesson planning, things like that? Is personal data going into it? It has to be clear what's being used and how it's being used, and that is not always that easy, because sometimes it's a bit like buying a black box. As I say, like for example, an HR system that's got some built-in AI, you're not entirely sure what it might be doing. So one thing that's important is, if you are buying in any system with AI, an AI aspect to it, is to understand from the vendor what the AI is and what it's doing, so that you can comply with your transparency obligations. It's worth noting the DFE does provide model privacy notice templates, but certainly you do have to tailor them. So now, having had a brief look at AI use in schools and contractual issues, I'm going to move on to the sort of more difficult topic, and that's automated decision making. So on the next slide, you'll see that essentially we've set out there the original position in relation to automated decision making, which is pre-Data Use and Access Act, and then we're going to have a look at what the current position is. When I'm talking about automated decision making here, what I'm talking about is essentially a decision is made without any human intervention, and it has either legal or seriously impacts on the individual's rights. So it is a it is a limited subset of what I'm talking about, but if you think about it, one of the areas where we do see automated decision making is in relation to filtering CVs. And if that's purely done by AI, there is no human, in terms of meaningful human intervention, and it certainly does have a serious impact on people as to whether or not they get through to the next round of something or whether they get a job. So you can see how these sort of things come into play. So whenever I mention automated decision making here, as I say, it's that subset of decision making by AI. And certainly the previous position under EU GDPR and UK GDPR prior to the changes under the Data Use and Access Act was that it was pretty heavily restricted. So that you could essentially only carry out automated decision making using personal data where it had a serious impact, where it's necessary for a contract, and it's quite hard to show necessity. It's authorised by law, or it's based on the explicit consent of the individual, which is quite hard to get, particularly if you're talking about an employment situation or you're talking about with students, because there's an imbalance in the relationship. And you might be aware that certainly from a GDPR point of view and UK GDPR point of view, you can't rely on consent where there is an imbalance in the relationship. So what's new? Where are we going under the Data Use and Access Act? I think there's been a recognition, as you'll see on the next slide, that essentially the position had to be relaxed. Otherwise, we would be falling behind from the use of an AI point of view. And that's not to say that, you know, it's a free-for-all. It certainly isn't. And essentially, what the position is now is that in relation to ordinary personal data, and as you may well be aware, there's two types of personal data. It's ordinary personal data like name, email address, things like that. There's special category data, which Hannah will talk about later, which is a defined list of things such as ethnicity, health data, religion, biometric data, and certainly special category data has to be handled with kid gloves. So ordinary personal data, the position is reversed. So subject to the controls that I've mentioned on the slide, you can carry out, once this comes in, automated decision making using ordinary personal data. The position is pretty much the same, however, in relation to special category data. As I say, it's kid glove time, where you're talking about special category data. And so automated decision making is only permitted in relation to special category data in very similar circumstances to what I've just talked about. So essentially where it's necessary a contract, authorised by law, or based on explicit consent. I think it's worth bearing in mind the controls around it. So even if you're not into special category data and it's ordinary personal data, essentially individuals will have rights in relation to automated decision making. So you'll see on the slide that they've got the right to be informed about the decision. So they need to know that there's automated decision making happening. They need to be able to make representations and contest it. So if you get a result which is computer says no, and they know it's automated decision making, then they have to be given the opportunity to make representations to say, well, I don't think that's fair because. And also they have the right to request some form of human involvement. I think as ever with data protection, the devil is in the detail, and the ICO is required, as you'll see from the slide, to develop codes of practice around this. So it will be interesting to see the detail around that and their view on this. But I think it's certainly something to think about, and it may free up you being able to adopt more AI systems in relation to maybe things such as recruitment. I think there's also essentially, EdTech. So moving on to the next slide, in terms of AI and EdTech and automated decision making, Hannah's talked about it earlier. It is very much a focus of the DfE at the moment, because obviously things are moving very fast and they need to make sure that anything that's being used in an educational environment is properly, that the personal data is properly protected. So, it might be used in terms of automated grading, for example, automated decision making. It could be used in terms of entrance exams, in terms of will it make an assessment from that point of view. Alternatively, and they're obviously things that may be quite contentious, it could also be used in things like obviously lesson planning and adapting learning tools for maybe those with neurodiversity or special needs. I think obviously if it's going to be used for things like entrance exams or automated grading which have an impact, maybe it's part of coursework from a GCSE point of view, then that needs to be very carefully thought out, and the rules we've talked about, you need to think about them. Certainly it is clear in ICO guidance relating to EdTech that DPIAs do need to be carried out, so a risk assessment in relation to the use of the personal data needs to be carried out before it is deployed, particularly where there's automated decision making with significant effects. And they've also mentioned, obviously, the safeguards that I've just talked about, so the ability to request human intervention. So I think if you are planning on getting EdTech with AI in, particularly if you're going to use it for automated decision making, you need to do quite a bit of due diligence in relation to the supplier. Now, obviously, there are general obligations before you buy technology which processes personal data to carry out due diligence, but I think it's particularly important where there's an AI aspect to it, and even more so where there's automated decision making. So you need to understand in terms of, Hannah talked about the enhanced rules relating to children. Does it comply with those? Is it an open or closed system, which we've just talked about? Are there significant decisions that are made using it? Do you understand that? Does the supplier understand that? Can they tell you how that all works? And also, have you got enough information to update your privacy notices, which, as I say, are particularly challenging where you've got EdTech in play. So I think there's no getting away, certainly, from AI, and it is certainly something that we are seeing in a lot of systems, but I think it's worth bearing in mind the sort of guardrails around it, and particularly in the context of EdTech. So I'm now going to pass back to Hannah, and Hannah's going to have a look at special category data.
Thanks, Joanne. So Article 9 of UK GDPR sets out what is classed as special category personal data. As Joanne mentioned earlier, this is personal data which is particularly sensitive and which therefore requires greater protection than ordinary personal data, which is things like your name, your address, contact details, things like that. And then Article 10 covers criminal offence and convictions data. So under the DUA Act, the Secretary of State has the ability to add new types or categories of special category data. So currently the Article 9 list is exhaustive, whereas this change allows flexibility. So it can address technological developments as they arise and ensure that personal data, particularly the more sensitive personal data, remains protected. It is important to note that whilst the Secretary of State can add new types or categories, but they don't have the power to remove any of the categories that are already set out in Article 9. So moving on to the next slide, where I'm going to have a quick look at recognised legitimate interests. So legitimate interests are different to some of the other lawful bases because it's not centred around a particular purpose. For instance, like contract or legal obligation, and it's not processing that the individual has specifically agreed to, where they've given the consent. So currently, to rely on legitimate interests, you're required to carry out a balancing test between your legitimate interests and the necessity of the processing, but also the rights and interests of the individuals whose personal data you're processing. And this is usually done by carrying out a legitimate interest assessment. So public authorities, it is important to note that when public authorities are carrying out the public tasks, you can't rely on legitimate interests as your lawful basis. Instead, public task is deemed more suitable. So under DUA, it introduces recognised legitimate interests as a lawful basis for processing. So this allows processing of personal data that is necessary for one of the specified reasons. So this means that if one of the recognised legitimate interests applies, you don't need to carry out the balancing test. So you don't need to carry out a legitimate interest assessment before you can rely on it as your lawful basis. Some examples of the recognised legitimate interests are direct marketing, intergroup transfers for administrative purposes, and processing that's necessary to ensure the security of your network and your IT systems. The DUA Act also confirms that public task only applies to an organisation's own tasks. So an organisation supporting a public authority should rely on another lawful basis rather than public tasks. So schools should therefore continue to rely on public task as its lawful basis for its data processing when it's for its core functions such as safeguarding and meeting its statutory obligations. But it may be that you could look at recognised legitimate interests or legitimate interests for something else as your lawful basis for that. It's also important to note that the Secretary of State has the flexibility to add to the list. So it kind of ensures that the law can continue to evolve to address new challenges and opportunities. I'm now going to pass back to Joanne, who's going to have a look at some of the DFE guidance in a bit more detail.
Thanks, Hannah. Ooh, looks like the sun's come up. Apologies in terms of being blanked out. Considering what the weather's been like, I can't believe that the sun's causing me a problem today in here. So keeping children safe in education, it's probably worth noting that it has been updated in the autumn this year. I don't think it's anything particularly earth-shattering in terms of what it's done. It does require governing bodies to understand how data can be processed, what lawful basis are for the processing of it, and there's an emphasis on the use of personal data from a safeguarding point of view. I think keeping children safe in education as well as the ICO is very keen to make it clear that if you need to share personal data from a safeguarding point of view, that's what's important in terms of safeguarding the child, and that data protection doesn't generally stop you from doing that. I think it also makes it very clear that there is a serious harm test and that schools have to withhold the sharing of personal data where there is the potential for serious harm. So moving on to the next slide, which is the DFE guidance itself. I'm sure that you're all familiar. Sorry about this. I'm sure that you're all familiar with the Data Protection in Schools guidance, which is a toolkit for compliance from a data protection point of view, and in some respects actually gold plates some of the guidance issued by the ICO to make sure that it's appropriate for students and pupils. There is some new guidance which I've put in the red box in terms of around retention schedules, having an appropriate retention schedule, and making sure that pupil records are correct and up to date. Surprisingly enough, they're also interested in the use of AI in schools, and there are links to various AI guidance. As I say, one of the things that they're interested in is making sure that EdTech is ring-fenced, not open generally. There are some videos around what is personal data, etc., that obviously can be used for staff training. And they've also obviously updated it to reflect some of the changes from the Data Use and Access Act. So yeah, I think it's included things in terms of updating, but I don't think so far there's been anything that should keep you awake at night in terms of what's happening from the update in those two sets of guidance. So moving on to essentially we're going to have a look at enforcement. So we're going to have a look at 3 schools cases that have happened in the last year to 18 months, maybe slightly pushing it, maybe about 2 years. They're specific to schools in the education sector, and I think they're interesting in terms of understanding what happened and what the ICO did and the approach that the ICO is taking in relation to schools. So the first one, Hannah's going to explain about what happened here. Passing back to you, Hannah.
Thank you. So in December 2023, the ICO issued a reprimand to Finham Park Multi-Academy Trust. And this was because they had serious failures to protect personal data following a cyber incident. In that, an unauthorized third party accessed and encrypted the trust systems using compromised credentials, and that affected nearly 2,000 data subjects. So a reprimand is essentially a formal warning to organisations where there's been a breach of data protection law. And when the ICO was investigating, they found that there were several serious shortcomings in the trust security practices. So they had inadequate technical controls in place. They had a insufficient account lockout policy. So that meant that repeated failed login attempts weren't properly restricted, and reversible password encryption was enabled, which kind of showed that this was a significant vulnerability. And also passwords could potentially be decrypted and exposed if the system was compromised. They also had a lack of multi-factor authentication and poor password management and staff awareness.
Seems a bit harsh, Hannah, that they've been named and shamed via a reprimand for something that could really happen to anyone. Is there a reason why the ICO sort of went down the reprimand route for this school?
Yeah, so it is quite a strict approach that the ICO decided to take, but actually this was the 4th data breach reported by the trust, and the ICO had previously issued guidance to them on each of the previous occasions, which the trust had failed to implement, and from the ICO's perspective, the incident showed that they were still very poor with security, and weren't really safeguarding personal data properly.
Well, that explains it in terms of if it's the 4th time and you've not implemented what the ICO told you to implement, then they tend to get a little bit agitated. So
yeah, I don't think they were happy.
Can understand that. So I'm going to have a look at another couple of cases, and the next one relates to the use of biometric data in the education sector. And what this relates to is a high school, and you'll see that this goes from July 2024. What the high school decided to do was to essentially use facial recognition so that they could operate a cashless catering system, which obviously on the face of it seems like a good idea in terms of a cashless system. Unfortunately, as Hannah mentioned, and I think I mentioned earlier, biometric data is special category data, and facial recognition, thumbprint, iris recognition is regarded as biometric data. So since it's special category data, it had to be handled very, very carefully. What essentially happened was that initially a data protection impact assessment was not done prior to deploying the system, and as you'll be aware, a DPIA is essentially a risk assessment looking at the use of personal data, and it has to be used where you've got novel technology that you are deploying. So the DPIA wasn't done initially. There wasn't consultation with the DPO prior to deploying of the system, and essentially it was an opt-out a letter sent to parents so that it was going to be deployed unless parents opted out. The ICO were not massively happy and essentially took action against the school. What the ICO was saying that they wanted is essentially that they needed the DPIA to be carried out prior to the essentially the deployment of the new technology. The opt-out consent was not good enough because they were using essentially biometric data and that special category data, and opting out rather than giving active consent is not good enough. The consent probably was being taken from the wrong people in relation to some of the students. So this was a high school where the pupils were aged 11 to 18, and certainly when you get to a particular age, a child's personal data rights are that of the child, and essentially the child has to be asked whether or not they're agreeing to things. No hard and fast rule, and I regularly get asked at what point does that happen, but you should be thinking about it for any child over about 12 or 13. Very much depends upon the understanding of the child. They also wanted to make it clear that a DPIA is not a tick box approach, and that this has to be sort of thought about in terms of when you're doing the DPIA. So I think they're useful things to think about. Obviously, a lot of people are thinking about the deployment of this sort of technology, but I think you're going to have to tread quite carefully and make sure that you've understood the risks, that you've understood how you're going to deploy it in a safe way, carried out a DPIA, etc. And obviously, you do need to be in close contact with your DPO from an early point in the process. So I think moving on to the next slide, I am going to talk about something that happened at Parkside Community Primary. Again, the ICO issued a reprimand. What happened here is that a laptop, the content of a laptop was mirrored onto a whiteboard, and the personal data of a number of people, including pupils, appeared on the whiteboard in a classroom setting, and people saw it. As you can imagine, that is not very helpful, and the ICO were unhappy about it. There was quite a lot of criticism of primarily the processes and procedures and the documentation that Parkside had. The ICO felt that they didn't have policies with clear guidance on the use of whiteboards. There wasn't clear guidance on the use of the essentially the school management system, and also the school case management system, and there wasn't appropriate staff training. I think one of the other things that counted against them was that the staff member concerned, when this came to light, didn't immediately report it internally. On the flip side, though, and I think it's worth bearing in mind that if you do come to the attention of the ICO, it's a bit of a balancing act that the ICO does. So there are the things that are counted against you in terms of things that have made it worse, and there are things that are essentially counted in your favour. And I think that, you know, there were the things that counted in the school's favour, and it's probably worth bearing these in mind, is that once the school itself found out what had happened, they immediately referred the incident to the local authority and the data protection lead there and followed recommendations. They carried out a formal investigation in relation to what happened and what the staff member did. They also looked at their policies and procedures. They categorised emails, and that actually, I should have mentioned that was one of the things that the ICO did say. There was no categorisation of emails. So if an email was particularly sensitive, then it had to have sensitive or highly sensitive in the subject matter to warn people that it's certainly not something that should go up onto a whiteboard. They also did, and this is something that the ICO does quite like, is carry out refresher training. I think one of the things that I would say to you is if you have a data breach or you end up with a complaint or the ICO starts an investigation, being able to demonstrate to the ICO that your staff, and particularly the more senior members of staff with responsibility for data protection, have had appropriate training, because it is something taken into consideration. So the school sort of took action, and that was sort of accepted as mitigation. And you'll see on the slide that the ICO also recommended further things that the school should consider in terms of enhanced training, clear procedures, and testing of processes, because I think that's the thing. It's all very well having a process, but if people are not following the process or it's not been tested, then it's not going to work from an ICO point of view.
Joanne, do you think that's why the ICO didn't end up fining them in this case?
Yeah, I think it's that, and I think also it's probably worth bearing in mind that there is a public sector approach that the ICO are taking. So the ICO are quite keen to take a sort of relatively balanced approach from a public sector point of view, because I think it realises, and it has acknowledged, that if you fine in the public sector rather than reprimand and sort of take action which involves payment of money, then it takes money away from things like the school and public sector services, and obviously things are very tight in that area at the moment. So they think it's a more appropriate way, is a bit of more of a carrot than a stick. I mean, obviously a reprimand's a bit of a stick because it's a bit of a naming and shaming, but they are quite keen to encourage compliance. I think it's also worth bearing in mind that they've just issued a statement that they're extending that approach. Hasn't always been very popular with people, in terms of some people think that some public sector organisations should be fined, but I think in context it's probably a balanced approach, and they have confirmed that they're going to continue with it, and fines will only be issued in the public sector for the most egregious breaches, so things that have caused actual harm to people, for example, things like that. So I think it's helpful to understand that, but it's certainly not a get out of jail free card, and it's certainly not good to be on the ICO's radar and being the subject of an investigation, because it will involve a lot of time, potentially legal fees, also the naming and shaming part of it. So they were three topical cases, and the sort of having a look at the approach that the ICO takes. We're now going to come on to what we see a lot in schools, and certainly we are seeing this growing and growing, both from a parent point of view, from a staff point of view, and that is DSARs. So I'm going to pass to Hannah, who's going to have a look at what changes have been made in relation to DSARs.
Thanks, Joanne. So as you're probably aware, under UK GDPR, individuals have the right to access and receive a copy of their personal data and other supplementary information, which is usually found in a privacy notice. And this is done by submitting a data subject access request or a DSAR to the organisation which holds their personal data. If you do receive a DSAR, you've got to respond without delay and within 1 calendar month of receipt, unless one of the limited reasons for extending the time limit applies. For example, it's complex. A lot of the rules around how to handle DSARs, the response times, how to search for the information, has been set out in ICO guidance rather than in the legislation to date. But what the DUA Act has done is it incorporates and it codifies some of the ICO guidance into legislation. For example, the stop the clock rule is included. This is where the time to respond is paused if you need to ask the requester for more information or you need to clarify the request to be able to locate their personal data. In addition, the position under the GDPR Act confirms that controllers are only required to carry out what's classed as a reasonable and proportionate search for a requester's personal data. It's reasonable and proportionate to your organisation, to the school, and that's something that you need to decide. It's not what's reasonable and proportionate to the person that's made the request. If a request is not satisfied with the response to the DSAR, they now have to first complain to you before they escalate that complaint to the ICO. And I'll have a look at the complaints process in more detail a bit later on. So in practice, the GDPR Act changes that are unlikely to change how you would tackle any DSARs other than the complaint point. But it is useful that the ICO guidance is now incorporated into legislation, especially when you're dealing with quite tricky individuals on the other side of a DSAR. So moving on to the next slide. The ICO have also updated their guidance on requesting clarification, which is quite helpful. So clarification can be sought if the scope of a DSAR is unclear and you hold a large volume of personal data about the person. If you're requesting clarification, you've got to be able to explain why you need clarification and tell the person of this, and also justify it to the ICO if you get asked. As we've talked about before, the deadline to respond to the DSAR pauses from the date clarification is requested until it's received. If the person responds on the same day, time won't be paused. If no clarification is received at all, you're able to wait a reasonable period of time. The ICO advises 1 month would be appropriate before closing the DSAR, but you've still got to provide any information that can be reasonably supplied without that clarification. So that could be like a personnel file if it's an employee that's made a DSAR or something like that. The clock will only stop for clarification about the scope of a DSAR, not if you need clarification on anything else. For example, the format of the personal data that you send in, or how to send it, where to send it, something like that. And we'd always suggest that you keep records of all communications around clarification and any delays with providing that, just in case a complaint is made and you need to respond to that. So moving on to complaints. At the moment, there's no legal requirement for controllers to have a formal complaints procedure. So at the moment, if, for example, you receive a DSAR, the person's not happy with your response, they could complain straight to the ICO. But under the GDPR Act, complaints must be directed to the controller before they can be escalated to the ICO, which means that highly likely you're probably going to see a higher number of complaints being received by the school before it can then be sent on to the ICO. Organisations must implement a complaints procedure, so some kind of electronic form, something like that, that people can submit the complaints to. Once you receive a complaint, you've got to acknowledge it within 30 days and advise of the outcome without undue delay. You've got to take appropriate steps to respond in those 30 days. The ICO advised that this would include things like making inquiries into the subject matter of the complaint, keeping the complainant informed about progress, things like that. And the Secretary of State has the power to require controllers to report complaint volumes to the ICO, but that doesn't look like it's happening at this moment in time, but it could be brought in the future. So it's just important to bear that in mind, and keep a record of the volumes of complaints you're receiving. So now I'm going to pass back to Joanne, who's going to have a quick look at the soft opt-in exemption for charities.
Thanks, Hannah. So what I'm talking about here is electronic direct marketing, and it's quite an important change for charities. Appreciate that not all schools are charities, but certainly some schools are charities, and some schools have charities allied to them. So it is something that's a fairly big change for charities. And where I said it relates to direct marketing, I'm not particularly talking about, certainly in the charitable context, where people are trying to sell goods or services. Direct marketing, and a lot of people are a bit surprised by this, from a charity point of view, covers fundraising, and it also covers the promotion of the aims of the charity. So obviously UK GDPR regulates the use of personal data. Where you've got electronic direct marketing, you've also got an extra layer of regulation on top of that. It was thought prior to the Data Use and Access Act that essentially charities and commercial organisations, there wasn't a level playing field, and that commercial organisations were in an easier position, because if a commercial organisation wanted to promote their goods and services, they could either do it via consent, which from a GDPR, UK GDPR level, is not easy to obtain, or they could use a soft opt-in, which is essentially, oddly considering its name, an opt-out approach to direct marketing. Charities, however, they could only use consent where we're talking about fundraising and promotion of aims. And as I said, it's not easy to get GDPR level consent. So there's been a discussion of this for quite some time, and the Data Use and Access Act has changed the position in relation to that, as you'll see on the next slide. So charities can now benefit from essentially a form of soft opt-in. So a charity, if it's wanting to fundraise, so for schools that's a charity wishes to fundraise or to promote its aims and ideals, it can either use consent or it can use the new charitable soft opt-in. And that's very similar to the commercial soft opt-in. And you'll see from the slide that if you want to use it, it is essentially an opt-out and can be used where you are essentially promoting an organisation, not a group organisation that somebody's had some contact with. There's got to have been some level of engagement. So if there's been engagement by an individual, that organisation can use it. It's got to be for the purposes of furthering aims of the charity or fundraising. Essentially, as I say, you've got to have had some level of engagement. You have to give the ability to opt out at the point at which personal data is collected, and also you need things like an unsubscribing emails. It's probably also worth noting is that it primarily relates to, well, it does relate to essentially electronic mail, which for the purposes of this is email and SMS. It doesn't relate to telephone. So I think it has been welcomed by charities. I think one thing to bear in mind is that if you have got consent, you can't just move to the soft opt-in. The ICO is very clear, is that if you've picked a lawful basis, you have to stick with that lawful basis, but certainly it will be interesting to know what happens if, say, the consent has expired, which consent does expire. Can you then move to a soft opt-in? Guidance will be provided by the ICO. So we're getting towards the end of the presentation. Hannah's going to cover a couple of additional points, and then we're going to have a look at a suggested timetable in terms of what you might be doing and when to comply with the Data Use and Access Act. So I'm going to pass back to Hannah, and Hannah's going to have a look at cookies.
Thanks, Joanne. So Consent is required for most cookies at the moment, except those deemed strictly necessary. For a cookie to be strictly necessary, it's got to be essential to provide the service which has been requested. So things like for the website to be able to work properly. Under DUA, it introduces exceptions to the current cookie consent regime. So consent wouldn't be required for cookies that are used solely for things like collecting statistical data to improve services or websites, and enhancing website appearance or performance, or adapting these things to user preferences. It is important to note that for any other cookies, things like advertising cookies, social media cookies, things like that, you will still need consent. The exceptions are conditional, so you have to still be transparent with individuals about the cookies that you drop in, what you're doing with the information you're collecting. Users have to have the right to object to the use of their personal data, and you can't use data beyond the scope of the exceptions. So it's got to be used for those sole purposes only. But it is hopeful that the amendments to the cookie rules will allow organisations to more easily collect statistical information to improve their websites and things like that. And turning to the next slide, just briefly. So under the current position, for PECA breaches, so things like breaches of cookie rules, breaches of the direct marketing rules, things like that, the ICO can issue fines of up to £500,000. That's the cap. But under the new position, there'll be enhanced enforcement powers. So the fines will be aligned with the UK GDPR maximum, which is up to £17.5 million or 4% of annual global turnover, whichever is higher. So it means that fines for breaches of PECA will have a significant increase from the current maximum. And it's important for schools to be mindful of this, particularly if you're making decisions around cookies and direct marketing, because you might have taken a bit more of a risk-based approach previously, but because of the increase in fines, it might be something that you need to be a bit more mindful of. So yeah, now Joanne's just going to have a quick run through the timetable and some practical guidance of things that you might want to consider.
Yeah, if we can move to the next slide, you'll see we've put together a suggested timeline. This is most definitely not written in stone, and these are just suggestions around the timeline that we've been given by the ICO and the government, and it may well be that different things happen at a different time in terms of guidance coming out, so we might need to adjust it a bit. So the first thing we'd suggest that you do is have a look at DSAR processes. As Hannah said, the DSAR changes, and I think I mentioned it earlier when I was looking at the timetable, is that the DSAR changes are in. So you need to review your DSAR processes. You need to make sure that you set up in terms of if you've got any standard correspondence with people to make it clear that any searches that you will be carrying out will be reasonable and proportionate as per the change, that essentially you know what you can do in terms of clarifying the request, you understand what the impact on the date for the responses from a stop the clock point of view. So if you've got any internal standard letters or you've got an internal manual about how you deal with DSARs or training materials, then you have to have a look at those, I would suggest, and update them to reflect the new position. The other thing that I would suggest is something worth doing early, is mapping your personal data. I think it's always useful to make sure that any record of processing activities or ROPA or any map of your personal data is up to date generally, but certainly because there are going to be changes in relation to things like what special category data, in terms of what controls have you got around special category data that you might need to extend to these new categories of special category data. Also understand your lawful basis. As Hannah mentioned earlier, There will be changes around recognise legitimate interests. Are you using legitimate interest? It's probably worth having a look at your data map to see whether or not you're using legitimate interest and whether any of them might help you, might make it easier. Because if you can use a recognised legitimate interest, you don't have to do a legitimate interest assessment, which does sometimes cause people problems. Moving on to the next slide. You'll see that I'm talking about monitoring ICO guidance. As I said to you earlier when we had a look at the timetable, the ICO has committed to issuing guidance to support the Data Use and Access Act, so it's worth having a look what's coming out and making sure that there's nothing that impacts on you. Have a look at your cookies. Understand what cookies you're using on the website. Might the changes and the relaxation in cookie rules help you? Might you have an easier time in terms of the consents that you're taking? You need to look at any preference centres that you're using and update your cookie policy. Complaints handling, as Hannah said, there will be a requirement that essentially you have a complaints handling process and procedure. The ICO is very keen to shift the first level of complaints to individuals because they're overwhelmed by complaints. I think they're anticipating over 45,000 complaints this year. So are you set up with your complaints handling? Have you put data into any complaints policy or procedure? Do you need to set up a completely new procedure to deal with complaints? Think about automated decision making. Do you currently use it? Is it compliant? Will it be compliant when the relaxation happens in relation to automated decision making? Or do you want to use it? Might it make your life easier from a recruitment point of view? And if you do want to use it, I think it's worth planning now as to how you might use it. And if you're going to use it via a third-party system that you're going to buy in, then it's probably worth starting to do some due diligence in relation to it. Sorry, it's cold season. In relation to charitable soft opt-in, if you're a charity, I think this is a big change. It's probably worth thinking about that and how that might impact upon you and whether or not you're going to move to the charitable soft opt-in. Look at AI in schools. I've just talked about automated decision making, but in terms of are you using ring fenced or closed? Do you know what AI is in all of your systems? Can you hand on heart say you know what you've got that's AI within school, and is it all compliant? And I think that obviously then leads to looking at EdTech contracts. There's been a number of changes that will impact upon what contracts should be covering and what your suppliers should be doing. So it's probably worth, one, if you're procuring new systems, to think about what the new rules are. And if you've got existing systems, go back and have a look in terms of, do they pick up? Do they recognise if there's processing of personal data by the EdTech provider, the special rights of the vulnerability of children, as it says on the slides? Do you have enough information from them to be transparent about your use of AI or the technology generally? Are they clear about where the data is processed? Is it clear from either due diligence or the contract? Is it all in the UK? Is it in the EU? Is it in the US? Because obviously if it's in the US, you've got data export issues to think about. And, what safeguards have they got around automated decision making and AI? Moving on to the next slide. And finally, and as I say, these are definitely not written in stone, but things you might want to think about. Monitoring ICO guidance. It's probably worth, when everything's just about finalised in terms of the guidance from the ICO, doing a full policy review. Is everything picked up in your policies now the new guidance has come out? Staff training. Obviously there are changes, and I did say in relation to enforcement action that appropriate staff training is always a good thing. The ICO like to know that people have been trained. It's sort of easier to say to the ICO, well, it's one of those things, unfortunately it's human error, but they were properly trained, so it shouldn't have happened. So pick up the new changes and obviously refresh any general changes. Look at your privacy notices. If you are moving into more EdTech, if you're wanting to do more AI, have a look at whether or not your privacy notices are transparent enough. update your data map or record of processing activities, and have a final look at your cookie banners, cookie preference centers, cookie policies, to make sure that they reflect any changes that you've made on the back of the relaxation of the cookie laws. So that's a quick canter through the changes. As you'll see, they're quite diverse in terms of the areas that they impact upon. We should be getting some guidance very soon. But that is the end of our presentation. If you've got any questions, I think we've got a few minutes, then please do ask, and we'll see if we can answer them. I think we've had one question about whether or not it will impact upon the role of the DPO and workload. I think in the short term, it will impact upon the DPO and their role, on the basis that there'll need to be adjustments of policies and contracts and things like that. I think the idea is, with the legislation being less red tape, that essentially it should make it a bit better for the DPO. But obviously the DPO will need to be heavily involved in terms of moving to new technologies. So I think that will include workload like facial recognition or thumbprint or AI. So yeah, I think it's a bit of a mixed bag, swings and roundabouts. Some ways it'll become easier, but in other ways I think there'll be more for the DPO to do. We had any other questions? I don't think we have.
Just if we'll be sharing the slides, I think, Joanne.
Oh, marvellous.
That was a question.
Yes, we will. We'll send out the slides. Marvellous. Well, nobody's got any more questions. Thank you very much for attending. If you could fill in the feedback form, that would be great. If you think about anything, by all means, feel free to drop me or Hannah a line about it. And thank you very much.